everybody. It's 10 o'clock, Friday, April 3rd, 2020. And we're here to talk about what's going on with the COVID-19 and how it's affecting the landlord and tenant law in Idaho. This is going to be an Idaho specific course. And the reason that I point that out is because this is being recorded. It may be online. So if anybody's got any questions about anything going on in other states, this isn't going to cover that. So why don't I start out for everybody who's here on this meeting and everybody's using Zoom or getting used to it. If you can go ahead and keep your mics muted, that'd help a lot because it helps keep the sound so everybody can hear. If you got some questions, go ahead and use the chat feature and pop those up and I can look at those on the side of the screen. I'll go ahead and I'll address some general questions and provide any clarification. If you've got any specific concerns, or you've got a specific case, or you want something dealing with your specific facts, go ahead and call me up and give it, and we'll set up an appointment and work through that later. Just sort of rules, ground rules here. I'm a lawyer, but this isn't an attorney-client conversation. There's no confidentiality here, and so don't tell me any secrets. And part of the reason why I'm not going to address any specific case situations is I don't want to create conflicts or anything along those lines. So, getting started, just kind of some high level. I'm Wyatt Johnson. I'm one of the founding partners here at Hansen Johnson. I've been practicing here in Idaho about 22 years. What I do now is primarily civil trial work, but over the past 22 years, I've done a lot of landlord tenant work. I've done a lot of leases, and I've done a lot of evictions and foreclosures. So I understand the subject area pretty well, and I expect that everybody's got some questions, a lot of questions about what's going on now. There is today a lot of information flowing around, and there is a lot of conflicting information. In order to straighten this out, I'm going to need to give you some background first, so you understand, so you can understand why what I'm saying applies in Idaho and why you may hear different things, but it doesn't change what I'm saying. The law regarding tenancy, landlords, tenants, leases, is jurisdiction specific. It's actually state law specific. And this is pretty important because in order to understand jurisdiction, just some real high level things, there's certain areas of law that are dedicated to the federal government, certain areas of law that are dedicated to the states. When you're dealing with landlord and tenant, that is an area of law that's dealt with the states. So there's not going to be any federal legislation directly forcing any sort of change on our landlord tenant law here in Idaho. There is some influential legislation with some incentives, but I'll get to that later. Second, one state's law cannot govern people in another state. So anything that's going on in New York, Louisiana, or California is state specific there. The effects of that rule end at its borders. Our state it has its own rules that deal with Idaho properties and leases here. So what we have going on here is going to be specific, these rules are specific to Idaho. You will hear that there are different rules pertaining to other jurisdictions, and those rules may be completely different from what I'm telling you here today. That's because those rules apply to a different jurisdiction. So a little bit more background first. Why don't I explain the whole concept of eviction? That's where we're focusing here. A lot of you have been through them, have done these as landlords. You've got a working knowledge of the system, but let me break it down and simplify what happens with the eviction process. There are two things that legally occur. The first thing that happens is you end a tenant's right to be on the property. When a tenant's under a leasehold, they've got a legal right to be in that property. The right is ended when they haven't paid rent, they're served a 3-day notice, and they don't cure within that 3 days. It also applies for breach of terms of the lease. But what that 3-day period to cure and their failure to respond does, that terminates their right to be on the property. So that's one part of the process. The second part of the process is removing them from the property after the right is terminated. That's what the eviction hearing and the eviction process is at the court. Is you go to court, tell the court this person's right to be on the property is gone. Now, court, I need an order forcing them to leave. And the effect of that court's order is that, of course, once the court gives that order, the sheriff can go in and forcibly remove somebody if they don't leave. That's the substance of what goes on with an eviction. In this case, in Idaho, there is nothing to date that has happened to change the first part of the process whatsoever. There's nothing in the governor's orders. There's nothing in any statute or nothing in any rule that changes the basic process that says if somebody hasn't paid rent, if they're in violation of their covenants and they get 3 days notice and they don't cure, their right to be on the property is terminated. That hasn't changed. I do not anticipate that is something that's going to change. I can get into that for other reasons. What has changed in the state, what has changed is nothing from the governor, nothing from the legislature. It's from the Supreme Court. What the Supreme Court has done is right now they have issued an order that is effective until April 15th, 2020. That order puts the courts throughout the state on a skeleton staff, and they only deal with emergency procedures. There is one form of an eviction that is deemed an emergency procedure, and that is where you are evicting somebody for the manufacture, delivery, or use of controlled substances, of drugs, meth houses. I don't come across a lot of those, mostly because the proof is usually really difficult. You have to have some actual proof that somebody is doing those substances, and really absent a conviction in the criminal courts, it's hard to get. So setting that aside, in all other ordinary cases where, especially what's going to be happening a lot now is non-payment of rent, the courts have not, they are not proceeding with those foreclosure proceedings. So in the ordinary circumstance, what would happen is you go ahead, somebody stops paying rent, you give them 3 days notice, and if they don't cure, the right's ended, you file a complaint in the court, and a hearing is set in 5 to 12 days from the filing of that complaint. And that's statutory, that's required, and the courts crank them out. Today, that procedure is on hold at least until April 15th. If the governor and if the governor extends the current order on stay home, which is set through April 15th, I expect the Supreme Court will probably follow suit. So this, the ability to have a hearing to have somebody removed from the property is going to be postponed until the courts start opening again. It is a big unknown once the courts open, what will happen and how quickly the courts will in fact start processing these hearings again. What's happening right now is at the courthouse, the courts are running a full docket, and they were before, and they had hearings set up to take care of that. The judges were taking care of a bunch of matters, and everything just sort of goes in order. Right now, while the courts are not holding hearings, all those matters are stacking up. So when the courts finally do open for business fully, there's going to be a big backlog. This is entirely unprecedented. Nobody knows how it's going to work. The court staff doesn't know how it's going to work. The judges don't know how it's going to work. And the Supreme Court's trying to figure it out. So we're just kind of along for the ride. So what does that mean? if somebody's not paying rent and they've got the 3-day notice and they haven't cured, there can be a delay before those people are moved out um, where a landlord just can't do anything. So what does that mean for the landlord? Well, it does not mean that the landlord is entirely stuck. While somebody is occupying that property, they owe the landlord for the value of that property. And this happens in certain circumstances. It's a principle of unjust enrichment. There's no free lunch there. So even if somebody's not able to be forced out, their obligations or debts to the landlord continue to accrue. I expect that will not change. And regardless of how long this goes, um, anyone who's in possession of the property will owe a debt to the owner for the fair value of that property. It may not necessarily be calculated under the lease, but that debt's there. The reason I don't expect that to go away is because if there were some rule or government action that deprived the landlord of that right to rent, it would probably be a taking. So you've probably got constitutional problems with that going away. It may be, though, that there are some other programs and some other incentives for landlords that may solve this problem. There is one right now, and this is one where people may have heard of this, on the federal level. And this ties into loans for multifamily housing that are Freddie Mae or Freddie Mac or Fannie Mae loans. And if you don't know, if a landlord doesn't know, if you go to the Freddie Mae and the Freddie Mac and Fannie Mae websites, there's actually a tool that the landlord, the loan borrower can type in, see if this is a Freddie Mac or Fannie Mae loan. In those cases right now, there are incentive programs by those backed loans that are provided by the it's the regulating body. Now I can't the federal housing the Federal Housing Financial Association that's back that. There are incentives for landlords who have loans on multifamily housing that are available to landlords that agree to rent abatement for their tenants during this pandemic. That's the one that I know of right now. There may be more. And it may be that just working with your banks, if you do not have a loan that is one of the Freddie Mac or Fannie Mae loans right now, I wouldn't be surprised if your banks voluntarily provide some sort of a similar program, or start getting compelled to if they're federally insured banks. The reason that they want to do that is this is an unprecedented situation. You don't have a situation where you have one tenant who's going to have trouble paying their loans. You got a situation where you've got an entire world of tenants that are unable to pay their rent. I think that the effort is that the lenders are realizing that we have to, everybody has to work together in order to avoid an entire disaster. So where does that leave everyone? It is a situation that is difficult to solved quickly. The renters are not going to end up getting a free pass out of this. They may get some postponement, but it doesn't look like they're going to get a free pass. Landlords are, if they watch, they can't get rid of renters who aren't paying, but they may have some ability to relieve the pressure on the side of their lenders to help them get through this. It's going to be a slow process, I think, to sort this out at the end of the day. It's probably to everybody's benefit to find creative ways to work through this and minimize the impacts as best as they can. Certainly for landlords, evicting a tenant who's not paying today is going to have limited value when you've got no other tenants out there who are able to pay. There is a bright spot on the horizon. Today, the small business loans are supposed to start processing, where the SBA is backing loans to small businesses who keep their payroll going. Just anecdotally, from what I've heard, I understand there are a lot of people applying for those loans. I think that's probably going to keep a lot of people who are tenants on payrolls, and they'll be able to move forward. It's a difficult situation, but I think we're all going to try and make the best of it. Does everybody know how to use the chat feature on Zoom? If you do, I'd be interested. Maybe a good way to process this is if anybody's got any questions, kind of a general nature, or want some clarification. If you go ahead and just run that on the Zoom chat, then I can see it, and it's easier because where we've got a larger group, it can be difficult trying to do those questions verbally. So, has anybody got anything anything that they'd like a little bit more clarification on? All right, this is a comment from Brent. He says he recommends that people talk to their mortgage lender. Their license and asking for payment deferment can trigger a mess. Oh dear. What? Tell you what, Brett. Why don't you unmute, and if you want to share what that mess is that you're talking about, your real estate licensure, right?
Correct. So I just asked my lender yesterday.
Mm-hmm.
I mean, we have expenses as landlords. We have mortgages to pay.
Yep.
These tenants, the Supreme Court order. I talked to my lender and my attorney yesterday about this scenario, and my lender advised that if I go into each individual mortgage company on my 4 properties and say, hey, can I ask for a payment deference? So I don't make a payment or make interest only for month 1, month 2, month 3, however long we're in this mess. Mm-hmm. He just cautioned against that. And like you said, finding creative ways to make your payment. Fortunately, I have a bit of reserves, but he says if you do ask for those forbearance and payment, it can trigger inability to refinance. There's a few other mechanisms that it triggers if you're going to go that route. So the end all was his advice was the best case scenario, just make your payment. Do the best you can to make your payment.
I think talk to and I understand where you're coming from. I think that if this is a short-term problem, that's probably the answer. The one federal relief that I've got is, and these are these rentals that you have, Brett. These are single family.
3 fourplexes.
Fourplexes.
Yeah.
Okay. Actually, and it may be that well, your loan's probably not Fannie Mae or Freddie Mac. They probably haven't.
So one is FHA, the second is conventional, and the third is VA.
Okay. Well, this is you check it because that's what the loans. It's when they resell on the market. So if you check, there's a tool on the Freddie Mac Fannie Mae website. You can actually type in your information. They can tell you if they've got your loan now. But what they have is that they are supposed to offer owners forbearance with the condition that they suspend evictions for renters who are unable to pay. So that's what the Federal Housing Finance Agency has directed. Now that was as of as of March 23rd. So it might be, and I understand. I think for right now, your lenders think you're going to have a problem. Work with your lenders as best as you can, but I wouldn't abandon it. It might be the message just hasn't gotten through. There is some accommodation upstream for that kind of situation. So I keep my eye out for it. Okay. Oh, let's see. I'm looking here, and there's a way to raise a hand here. Okay. V20. What? It's V. Who is V20? Let's see. All right. There's a question here on where to direct tenants for help rent payments. Give me a sec here. All right, 3-day notices, whether or not to serve 3-day notices or not. Technically, right now, and there's nothing stopping you from serving 3-day notices in the same way that you always did, and starting the eviction process as you would. It's just that once you do, you can't. We don't know when you're going to be able to court and get the person taken out. But I think the strategic way to look at it is that while you could serve a 3-day notice, and you know you can't do anything about it, this might be a situation where it is more valuable or more beneficial to go ahead and make an effort to work with the tenant. And the reason being is because you go ahead, you terminate the tenancy, you can't get them out, and very likely there's no other tenant who's going to be in a better position that's out there. I mean, until this works out, the same forces that are affecting the person that's in your property are the same forces that are affecting people in other properties. What you might do is maybe negotiate modifications to the lease, suggest something where you say maybe I'll defer payments, but we can add, depending on how long the lease is, how long the tenant's there, maybe offer to have a periodic payback, so that tell you what, we'll defer this month, maybe next month if you have to, but what we'll do is we'll go ahead and we'll add to the remaining lease payments going forward. That might be a closer path to getting you paid than simply cutting somebody off. The odds of collecting, once you cut off a tenant and given the 3-day notice and basically move to evict, while you can collect and there is a debt there, a lot of people don't end up collecting that because it's just practically difficult. So serving 3-day notice, I think that strategically, probably under the circumstances, there's less to be gained by serving the 3-day notices quickly. There's no reason if the person isn't paying right now and the world comes back to life, there's no reason why you can't serve them the 3-day notice later, and you go ahead and it's going to be just as effective then. Let me see, what else have we got here?
Angston, this is Brett. May I add to what you just shared? I've done a number of evictions pro se, and I found out the hard way last eviction claim that so my properties reside in LLCs, and a corporation cannot self-represent. So I show up to the trial, and judge is like, "Well, where's your attorney?" "Oh, good question." Came back a week later with the attorney. Anyways, I found out through that. So I guess my main question is for those individuals that want to exercise due process, serve a 3-day notice. If we go into the iCourts portal and file the claim, is the clerk denying the claim because of the Supreme Court order?
No. You're able to go ahead and file the complaints. The Supreme Court order, all complaints are being filed. The only thing that stopped with the courts are the hearings. So otherwise, deadlines, statutes of limitations, those things are all running, and the courts are accepting filings. And as a pro se, I'm not sure. I got to be honest. I'm not sure exactly how that happens. I know that for the attorneys that are already in there in iCourt, it's very easy. And going in and filing a complaint, the clerks do need to accept those. The court's just not going to do anything about it. So even though the statute says you've got to have a hearing within 5 to 12 days, that's the usual process. Right now, there are no eviction hearings for standard non-payment of rent. So.
Because my thinking, and this could be erroneous, is if being a knowledgeable landlord, if somebody wanted to serve, they throw in a 3-day notice, they did not vacate, they file for the hearing and playing on the tenant's ignorance or not knowing of their rights, or the Supreme Court scenario, if they have a summons that they can serve. I've run into it where I've gotten the hearing and the tenant's vacated before the trial. Because they're scared of going in front of the judge. And if I have that hard date, it kind of motivates them to move out. But if they're not scheduling a hearing at all, then that play is not there.
Well, Brett, 2 things here. One, this is a public forum, so I mean, if you've got your strategy, there may be tenants on this line, so you want to be careful of that. But I mean, just the no hearings. I mean, it's just right now, you will not get a hearing. The clerk's not denying it. The hearing will be scheduled whenever the courts reopen.
Yeah.
Nobody knows when that's going to be.
Gotcha.
So, I mean, it just, that's what I'm saying is your leverage in terms of the hearing that you might ordinarily have as a landlord, it's just not there. So, I think this is a situation where you got to sit down and evaluate the hand that we've got and go forward. My assistant just pinged me and reminded me that there's also the tolling of service. The Supreme Court's been continuing to issue supplemental orders. Right now they're tolling service too. Although I think that doesn't change this discussion much. Anybody else? Any other points or clarifications? Just kind of a general nature that we've got. Let's see. So 3 days. Let's see what else. All right. Well, tell you what, guys. I'm gonna guess that this is probably well, wait. Let me here's a new question. Addendums to a lease. And this is a follow-up on my suggestion that maybe you can work something out with a tenant, like make staggered payments or something along those lines. Question is, do you need to do a formal written addendum to the lease, or is an email all right? As far as the formal technicalities, if any leases that are less than a year long, you don't necessarily have to have a writing for it to be technically enforceable. As a proof issue, it's always really a really good idea to get it in writing. And the reason is people intentionally or unintentionally remember things differently later on. An email will serve not only to memorialize what might otherwise be a verbal agreement, but if you do an exchange with email, I I find that under the circumstances, if there's no dispute that these are from the email accounts, I think an email exchange back and forth, if you say, okay, landlord, I agree that we're going to make payments in this way, and the landlord responds and says, I agree, and you got that from both email accounts, in my view, that'll satisfy a writing the writing requirement that's necessary to amend a lease. So an email back and forth, especially under these circumstances, because we're essentially under a stay-home order, courts are going to be very receptive to email amendments to leases. Okay. Mark Dale just noted that the Idaho Apartment Association has put a promissory note form out for people to use for basically working out a promissory note from a tenant. Basically have the tenant give you a promissory note with payment terms on it for paying the rent. That's a good solution too. So, and that's something somebody can sign it, scan it, send it over to you. Technically, you want to, if you're dealing with a promissory note, if you're the creditor on that, you want to have the signed original of that note. But really, what you're just looking for is evidence of the debt. That'll get you there. All right, it's been 30 minutes, and I think that we promised that we'd keep that to about this. If anybody has any specific scenarios that they'd like to walk through with it in their given situation, be happy to talk with you about it. That's what I do. So you can go ahead and give us a call down in Hansen Johnson, 208-384-8588. Or you can reach my assistant Lorena directly at Lorena at angstman.com. She'll be able to get something scheduled and move forward. We're staying open. We're fully functional during this time. We actually took advantage of that stimulus bill, so we're going to keep our people moving and working. And I hope you all are able to find a way to make it through this as well. Good luck, and I hope that this was some good information for you today. And we will see you all the next time.